Folks, on October 19th, 1781, the British surrendered at Yorktown. The most powerful empire in the world had just lost to an army of a bunch of rebellious colonies. And legend has it that when the defeated British marched out, the musicians were playing a tune called "The World Turned Upside Down." Now, historians have some serious doubts about whether that song actually played, but the lesson survived for a reason. Because the old order had been reversed. The people enforcing the system had lost control of that system. The world had turned upside down. 245 years later, our cannabis world has been turned upside down because the lawyers for the Drug Enforcement Administration, the DEA, have now filed their post-hearing brief arguing that marijuana cannot remain in Schedule 1. And unlike the story about Yorktown, this one isn't a legend. I have the brief. I read it. Let's go over some of its choicest excerpts. Here are some of the government's own words. Marijuana can no longer remain in Schedule 1 because it no longer satisfies 2 of the 3 statutory requirements of 21 U.S.C. Section 812B. The DEA's lawyers, in the marijuana rescheduling case filed by the DEA's Office of Chief Counsel, the world turned upside down from decades of prosecutions. Another crazy development in cannabis law. Hi, I'm Tom Howard. I've been a cannabis lawyer and activist for more than a decade, and on this channel we actually read the laws, the court decisions, and the government filings instead of just reading somebody else's headline about them. So if you want to know where federal legalization is actually going, subscribe now because this case is getting very close to the part that matters. And what the DEA lawyers just put in writing is astonishing, at least historically speaking. In 1970, Congress created 5 schedules under the Controlled Substances Act, and Schedule 1 has 3 statutory requirements. A drug in Schedule 1 must have a high potential for abuse. It must have no currently accepted medical use in the United States. And there must be a lack of accepted safety for use under medical supervision. That's the statute. Those are the elements that they've been cramming down our throats for decades. But now the government is in a new position where marijuana is no longer meeting 2 out of 3 of those. The DEA lawyers say the government comes before this tribunal in support of its position that marijuana as defined under 21CA should be transferred from its current placement in Schedule 1 of the CSA to Schedule 3 on the basis that marijuana no longer fits 2 of the 3 statutory requirements to remain in Schedule 1. I mean, read that again. This is not a hemp loophole. This is not CBD. This is not some synthetic cannabinoid they made up in a lab. Marijuana as defined under 21 U.S.C. 802.16a, the Controlled Substances Act definition of marijuana. And that exact definition becomes very important because the federal government has already created one of the strangest drug policy arrangements I've ever seen. But first, let's look at what else is in this brief. The government has submitted proposed findings of fact to the Chief Administrative Law Judge, Derek Julius. These are proposed findings the government is asking the judge to adopt. The judge has not adopted them merely because the DEA wrote them, but listen to what the DEA lawyers are asking their own tribunal to find. Quote, the vast majority of individuals who use marijuana do so in a manner that does not result in dangers to themselves or their communities. We have been screaming that for decades. And now it's in black and white and signed by a dog pile of government lawyers. Look at the signature block on this thing. And look how far we've come. Quote, risks to public health are lower for marijuana than other comparator substances like heroin, codeine, and oxycodone based on review of emergency room visits, hospitalizations, unintended exposures, and overdose deaths. End quote. Again, that doesn't mean that marijuana has no risks. The DEA is not arguing that. I've never argued that. Scheduling is supposed to involve comparing the drug's characteristics with the statutory schedules. And after looking at the evidence, the government says marijuana risks line up better with Schedule 3. The DEA asked the judge to find that, quote, there is consistent evidence across multiple databases referenced in the 8FA that show while marijuana poses a risk to public health, it is lower than that posed by many comparator drugs. And 8FA just means the 8-factor rescheduling analysis under the Controlled Substances Act, CSA. Now, we get to the requirement that has always made marijuana Schedule 1 status so absurd. Schedule 1 always says that there is no currently accepted medical use, except America built an enormous medical cannabis system while the federal government was busy insisting that the medical use didn't exist because it wasn't FDA approved. The government says that there are more than 30,000 healthcare practitioners across 43 jurisdictions to recommend marijuana to more than 6 million registered patients. And HHS found sufficient scientific support for currently accepted medical use for 3 conditions: chronic pain, anorexia associated with a medical condition, and nausea and vomiting associated with chemotherapy. And here's their legal dagger. The government writes, quote, "This tribunal need only find that marijuana has CAMU for 1 medical condition for marijuana to be transferred out of Schedule 1, end quote. CAMU just means currently accepted medical use. And then the DEA lawyers went on. Quote, "HHS recommendation found that marijuana had CAMU not for 1, but 3 therapeutic conditions," end quote. And 1 was required, and they've shown 3, and they argue something even stranger happened during that hearing, the evidentiary hearing that went on for weeks. Some of the people fighting rescheduling helped establish the government's medical use case. Here's a direct quote. Quote, "The government's witnesses, along with several opposition party witnesses, testified that marijuana has a medical use," end quote. Here we are again, the world turned upside down. The testimony from opposition witnesses acknowledging evidence of therapeutic benefit in areas including pain, wasting syndrome, appetite, and severe nausea. Now they disagree about the strength of the evidence. That's important, but it's a very different argument from saying marijuana has no accepted medical use whatsoever. And Schedule 1 requires no currently accepted medical use in the United States. That's the problem. The DEA historically used a 5-part test to determine whether a drug had currently accepted medical use. But the Office of Legal Counsel examined that approach, and according to the government's brief, Office of Legal Counsel again is OLC. According to the government's brief, quote, "OLC concluded that DEA's current approach to determine whether a drug has CAMU through the application of its 5-part test is impermissibly narrow." DEA's own test, impermissibly narrow. Why? Because the legal analysis could simply not ignore what is happening across the United States. Widespread medical use in treatment in the U.S. by licensed practitioners under state-authorized medical programs. And it gets worse for the old Schedule 1 argument. The government explains that after formal rulemaking begins, quote, "DEA must accord HHS scientific and medical determinations significant deference and may not undertake a de novo assessment of HHS findings at any point in the process," end quote. In other words, DEA doesn't get to throw out all of HHS work into the trash and start over because it doesn't like where its science ended up. And where did HHS's evidence land? Medical use, accepted safety under medical supervision, and an abuse dependency profile that the government says better fits Schedule 3. And now we get to the really weird part. Remember that definition that I told you to keep in mind about marijuana in the beginning? The issue the government puts before Judge Julius is whether the controlled substance marijuana as defined under 21 U.S.C. 802.16a should be transferred from Schedule 1 to Schedule 3 of the CSA, end quote. That's the question, the controlled substance marijuana. But back in April 23rd of this year, DOJ did something very unusual. It issued a final rule putting FDA-approved marijuana products, marijuana subject to qualifying state medical marijuana licenses, into Schedule 3. Other marijuana remains in Schedule 1. DOJ says it used its treaty authority under the Controlled Substances Act to do that. So right now, federal law has this bizarre split. State licensed marijuana, Schedule 3. Other marijuana, Schedule 1. The Controlled Substances Act defines marijuana once. The April rule itself says marijuana shall have the meaning as set forth under 21 U.S.C. 802.16a. And then the regulation makes the schedule depend on whether that marijuana is an FDA-approved product or subject to state medical marijuana license. Same substance, same definition, different schedule, depending on its regulatory status. I think that creates a serious statutory problem for the first executive action rescheduling the medical marijuana half of the only definition of marijuana under the Controlled Substances Act. And I'm going to be clear about what is fact here and what is my legal analysis. The fact is that the DOJ created this split and says that it has the authority to do it under the treaty provisions of the CSA. My legal read is that the cleaner answer is to reschedule the controlled substance Congress defined, all of it. DEA, the government is asking Judge Julius to determine not whether medical marijuana should be transferred, not whether a special substance called state-licensed cannabis should be transferred, but it's whether the controlled substance marijuana as defined under 21 U.S.C. Section 802.16 should move from Schedule 1 to Schedule 3. And the government's conclusion could hardly be clearer. Let's look at the government's closing argument. It's page 49 of the brief. Marijuana can no longer remain in Schedule 1 because it no longer satisfies 2 of the 3 statutory requirements of 21 U.S.C. Section 812B. The recommendation found that marijuana had CAMU not for 1, but 3 therapeutic conditions. And then, further, none of the testimony from the opposed parties contradict these findings. And immediately after that, marijuana most appropriately belongs in Schedule 3 because its abuse potential and dependency profile most align with those substances in Schedule 3. On the very next page, the government asked the tribunal to recommend marijuana to be transferred from Schedule 1 to Schedule 3. That's their case. This DEA that has been fighting us for decades has changed its tune. So what happens next? Judge Julius now has the record and the post-hearing briefing. DEA administrative law judges prepare recommended decisions containing findings of fact and conclusions of law. That recommended decision then goes to the DEA administrator, who makes the final agency decision. So we're getting close, and I'm going to make a prediction. This is my prediction, not the DEA. It has not announced the timeline. But if the administration intends to finish broader rescheduling, I think the obvious political incentive is to get that win out before the midterm elections. Take credit, tell millions of cannabis voters you finally broke marijuana out of Schedule 1, tell the industry that you delivered, and steal some votes with it. So when does all of this happen? Here's what the regulation actually says under Section 1308.45. It says, as soon as practical, after the presiding officer has certified the record to the administrator shall cause to be published in the Federal Register his order in the proceeding. That's the next major thing we are waiting for. Judge Julius finishes his work, the record gets certified to the administrator, and then, in the words of the regulation itself, as soon as practical, the administrator is supposed to publish that final order. And that order is supposed to contain the final rule, the findings of facts, and the conclusion of law behind it. Normally, the effective date has to be at least 30 days after publication, although the regulation expressly allows an earlier date if the administrator finds that public health or safety requires it. So while we're not at Yorktown's Treaty of Paris just yet, we may finally be at Yorktown. The government's own lawyers are asking their tribunal to say that marijuana has accepted medical use, that it no longer satisfies the requirements of Schedule 1, and that it belongs in Schedule 3. Their words, quote, marijuana can no longer remain in Schedule 1, end quote. The world's turned upside down. And so join another 92,000 subscribers and let's get to 100,000. Like this video, share it with somebody who still thinks federal marijuana policy makes sense, and tell me below, do you think this finishes before the midterms or do they kill it entirely? And if you're in the cannabis industry and want to work together, check out the pinned comment. As they say in the law, I'll see you as soon as practicable, or once we know more.